Hello everyone, I'm Chad Van Horn, founding partner of Van Horn Law Group, and today we're going to take a deep dive into 341 meetings with the trustee, and you're going to see a reenactment of a 341 meeting. I hope it's helpful to you.
Good morning. My name is Glenn Keys and I am the trustee assigned to your Chapter 7 bankruptcy case. We are here today to conduct the 341 meeting of creditors.
The trustee's introduction will set the stage for the meeting. Make sure you pay attention to anything that they say, answer their questions honestly and directly.
Please state your name and address.
My name is Debbie Roberts and my address is 5767 3 Mile Road.
Always provide complete and accurate information. This is going to set the tone for the entire meeting.
Have you reviewed the bankruptcy information sheet?
Yes, I have, yes.
The bankruptcy information sheet is a crucial document that explains the different chapters of bankruptcy and is required by every attorney to give that out to their client for review. It's important that you review that prior to the meeting because they're going to ask about it.
Have you moved since you filed your bankruptcy?
No, I haven't.
If you moved, it's essential that you update the records not only on your driver's license, but also with the bankruptcy court. Any information needs to be reported to the court immediately.
Did you sign your bankruptcy schedules?
Yes, I did.
Signing your bankruptcy schedules means that you're attesting to the information in there that it's true and accurate under the penalty of perjury. So it's very important that you review all the documents that you're signing and understand it before you sign it.
Is all the information truthful and correct?
Yes, it is.
Accuracy is paramount. False information can cause you to lose your discharge or worse, end up in prison. Now that rarely happens, but you need to make sure that these schedules are accurate.
Have you listed all of your assets?
Yes, I have.
Listing all assets is crucial. I had one case lose their discharge over not listing some golf clubs that were worth hundreds of dollars. So you got to be very careful in making sure that you list all of your assets.
Have you listed all of your debts?
Yes, I have.
Just like assets, all debts must be listed. If you don't list a debt, they may be accepted from the discharge because they did not get notice of your bankruptcy. So it's really important that we list all of your debts.
Does anybody owe you any money?
No, they don't.
If someone owes you money, it's considered an asset and the trustee may go after it. So it's really important if anybody owes you money that you list it on your schedules.
Are you using or paying on credit cards?
No, I'm not.
Using your credit cards right up until bankruptcy or even after bankruptcy is going to raise a lot of red flags. You want to make sure that you stop using and paying on your credit cards as soon as you decide that you're going to file for bankruptcy. If you don't, you can lead to that debt being non-dischargeable or worse.
Have you bought, sold, or leased anything like a car in the past 12 months?
No, I don't think so.
Any significant financial event, especially in the last 12 months, needs to be reported to the trustee because they're going to look to see financial disclosures if you got a lease, a vehicle, or if you purchased a house, you're going to have financial disclosures when you did that, and they may look into those financial disclosures to make sure you're being honest now.
Have you given any money or property valued at $1,000 or more to your family members in the past 4 years?
No, I have not.
Transferring assets within the last 4 years while you're insolvent can be considered a fraudulent or avoidable transfer. So the trustee is going to look to see if you transferred any assets right before filing bankruptcy, and the trustee may be able to go after those assets, sell them for the benefit of the creditors.
Have you sold, transferred, or donated any property in the past 4 years?
No, I have not.
Again, transparency is key. If you have sold anything of value within the last 4 years, make sure that you're reporting it to the trustee and it's listed on your scheduled statement of financial affairs. This is just so the trustee can look to see if there's any assets that they can go after to collect to pay the creditors.
Have you owned any real estate in the past 4 years? And if so, what happened to it and what did you do with the money? Have you paid down your mortgage or put additional money in your 401k or IRA in the past 12 months?
I have not owned any real estate and I haven't made any additional payments to my mortgage or my retirement account.
Now, this question can be tricky because the trustee is looking to see if you did any bankruptcy preparation, meaning you're turning non-exempt assets into exempt. In Florida, we have the homestead exemption. Retirement accounts, generally speaking, are exempt. But if you sold non-exempt assets and put it into an exempt status within that period when you were considering bankruptcy, then your homestead, the retirement account, may not be exempt. So this can be very tricky. You definitely need to speak to an attorney if you have any of these issues well before filing for bankruptcy, but definitely before the 341 meeting.
How long have you lived in your current house?
About 3 years.
Your length of residency determines what exemptions you're allowed. Generally speaking, if you live in a place for 2 years or longer, you get that state's exemption. So if you are a recent resident to whatever state your 341 meeting is in, make sure that you have the right exemptions, because again, this can get really tricky and have a big impact on not just your exemptions, but your case in general.
Do you have any joint debts with your spouse?
Yes, we have a joint mortgage.
Joint debts can make a case difficult because there are certain exemptions, like a tenancy by the entirety's exemption, that you can take, but if there are joint debts, that exemption might not hold up in court. So be very careful if you have joint debts, and especially if only one spouse is filing, regarding what exemptions you're allowed to use.
Has your spouse used your credit cards?
No, he has not.
If your spouse used your credit cards and bought things only for him or her, then the creditor may have the right to be able to go after your spouse. So be careful if you have a spouse that's running up credit cards and you think that you're going to get it discharged in your bankruptcy. The creditors know this trick and they may go after your spouse.
What caused you to file bankruptcy?
Medical problems.
This is usually the toughest question for my clients, and they want to tell a long story about what led to the bankruptcy filing. The trustee really isn't looking for the long story. They're looking for exact details on what happened. So if it was a medical issue, if it was a divorce, job loss, be very, very, very direct with that answer, and don't go into the long story unless the trustee asks for it.
Are you using or paying on credit cards, and when was the last time you paid on the credit card?
I'm not using them, and I paid them about 6 months ago.
Recent payments on a credit card may be considered a preferential payment, meaning that creditor got more money than the other creditors would have received. That's usually a 90-day look-back period for regular creditors and a 1-year look-back period for insiders and family members. So you might want to do a full accounting of that before you file, and definitely let your attorney know before the 341 meeting if you made any significant payments. That concludes our in-depth tutorial of the 341 meeting. Make sure that your answers are concise, honest, and that you're prepared going in. And if you have any questions, of course, you can reach out to me at Van Horn Law Group. Thank you.